Many thanks, Jonathan, and I'd like to join the organisers in paying my respects to the traditional owners on the land on which we meet, and pay my respects to their elders, past and present. Well, I was just saying to Russell, I was slightly alarmed when I heard him announce the conference theme as Inspire and all the other things that started with I, because my invitation letter told me that the theme was going to be Old Structures in a New World. So I thought, oh, I'll build my talk around that, but I hope it will also do all those things that start with I as well. And I was also asked to focus on the International Court of Justice. And it struck me, of course, when one's talking about old structures in a new world, that the International Court of Justice is a perfect example of that theme. So the idea of the theme in my invitation letter was, how to examine how the structures, the institutions of the United Nations, which were designed almost 70 years ago, how they're adopting to a raft of problems that couldn't have been imagined at the time of the adoption of the UN Charter. Issues such as climate change, environmental degradation, terrorism, and massive global inequality. So, in fact, the International Court of Justice was very closely modelled on its predecessor, the Permanent Court of International Justice, which operated from the early 1920s and was in one sense a creature of the League of Nations. So, in a sense, the International Court is even older than the UN, and as a nonagenarian, it's perhaps even more set in its ways and creaky in its joints. Now, this picture, I just have a few pictures that I found on the court's website, and this one is the very first, the inaugural session of the International Court of Justice in 1946 in the Peace Palace. And you can just see there in the extreme right of the photo, the then Princess Juliana of the Netherlands, who attended to inaugurate it. She, of course, is now she was the grandmother of Queen Beatrix and the grandmother of the new King of the Netherlands. Her grandmother, in turn, provided many of the furnishings for the Peace Palace in The Hague. So there's a very close link between the Netherlands royal family and the International Court of Justice, at least at the ceremonial level. Well, I was taught international law at the University of Melbourne in the 1970s by one of the keynote speakers tomorrow, Professor Gillian Triggs, who was a brilliant teacher. But I remember in the 1970s, when I studied international law, in 1979 to be precise, the court was then considered to be a completely moribund institution. In fact, I remember Gillian had set us as one of the possible topics to write about in our international law essays, why is the International Court of Justice a failure? And it seemed in the 1970s to be a great failure because it was only hearing a very, very small number of cases, and its jurisprudence seemed to offer very little to the resolution of global problems. Indeed, in the 1970s, there were a couple of years when the court had absolutely no cases pending, and other years, if you go back and look at the publications of the court during the 70s, there were some years in which it didn't deliver a single judgment. I did ask when I was at the court recently, well, what did the judges do during that time? There were still 15 judges. And one of the drivers who could remember back to that time said there was a lot of tennis played. That's not the case now. So in the 1970s, respondent states boycotted proceedings in 7 out of 8 contentious cases. So you can see why it was widely considered not to be doing very well. And the court seemed in those days far too ready to avoid any difficult issues of adjudication. And I guess from Australia's perspective at the time, the most notable example was in 1973, when the court effectively sidestepped the issue of whether France's program of atmospheric nuclear testing in the Pacific was consistent with international law. That issue was raised in a case brought by Australia and New Zealand against France in 1973, and the court effectively chose not to deal with the merits of the case, taking refuge in the claim that France had in any event made a statement saying it had decided to discontinue with its testing program. The ad hoc judge for Australia in that case, Sir Garfield Barwick, the then Chief Justice of the High Court, made what international lawyers at least would consider his finest judgment ever in talking about the merits of that case. But I think in retrospect, we can see the 1970s as a very low point. And over 3 decades later, the picture has changed quite profoundly. And so the argument I want to make in my brief presentation today is that the International Court of Justice, while being a very old structure, is an essential element in the UN system of peaceful dispute resolution. So what I want to do is to begin by describing the court and its jurisdiction. So this is a picture of the current membership of the court. So you'll see there are 15 judges. There's a cycle of elections. Each serves for 9 years. And there's a 3-year cycle of elections. So you've got judges, 5 judges going off the court every 3 years. By almost unyielding tradition, this is provided for in the court statute, but it's almost locked in stone as a tradition. 5 of the judges come from each member of the permanent members of the Security Council. So you can see Judge Skotnikov from Russia, Judge Abraham from France. They're both sitting in the front row. And then you have Judge Shui Han-chin in the back row from China. You have Sir Christopher Greenwood from the UK in the back row, and beside him Judge Joan Donoghue from the United States. The other 10 positions are in a more flexible tradition, elected from regional groups, the UN's regional groups, Latin America and the Caribbean, Eastern Europe, Africa and the Middle East, Asia and Western Europe and others. And from our region, there's, you can see in the front, Sir Kenneth Keith from New Zealand, and if you think of our larger region, Judge Bandari from India and Judge Hisashi Owada from Japan. Now the president of the court, and he's sitting right in the middle, is elected by the members of the court for a 3-year term, and the current president is President Peter Tomka from Slovakia. So the court sits in the beautiful Peace Palace, which turns 100 this year. There's a big ceremonies at the end of this month celebrating the 100 years of the Peace Palace, which was actually a gift by the American philanthropist Andrew Carnegie. And they're still inside the Peace Palace. You can still see the $1.5 million US check that he wrote. They didn't seem to ever cash it in to build the building, but that's how much it cost to build that building exactly 100 years ago. Now, the statute of the court makes clear that its task is to adjudicate between states. So it doesn't hear cases against individuals or groups who may be responsible for violations of international law. This often leads to confusion with other institutions based in The Hague, much more recent institutions such as the International Criminal Court or the International Criminal Tribunal for the former Yugoslavia, which of course have a mandate to hold individuals responsible for breaches of international law. So the court hears cases, disputes between countries, but it also has a very interesting capacity to give advisory opinions when requested by an appropriate organ of the United Nations. So examples of that include, for example, the request by the World Health Organization for an advisory opinion on the legality of nuclear weapons delivered in 1996, and UNESCO's request for an advisory opinion on the legality of the Israeli barrier wall, which was delivered in 2004. And the most recent advisory opinion that the court has delivered was on the legality of Kosovo's declaration of secession from Serbia, which was handed down in 2010. Now, a major constraint for the International Court of Justice in the pursuit of an international rule of law is that its jurisdiction is optional. Countries can choose to accept the court's jurisdiction either generally or for the purposes of a particular case. And it's striking that of the current 193 members of the United Nations, just 70, so less than half, have accepted the court's jurisdiction generally. Now, it's striking also that even though the permanent members of the Security Council are all more or less guaranteed, as it were, that one of their nationals will serve on the court, of the permanent 5, only the United Kingdom still has a valid acceptance of the court's jurisdiction under the optional clause. France and the United States did have declarations, but they withdrew them, France in 1973 at the time of the nuclear test cases, and the United States in 1984 when Nicaragua brought a case against it. And neither China nor the Russian Federation have ever made a declaration under the optional clause. And it also should be noted that of the 70 countries that have accepted the optional clause, which do include Australia, many of them have specified exceptions to their acceptance of the court's jurisdiction. So Australia, in 2002, Australia made a reservation to the jurisdiction of the court, and it excludes, for example, and this is a quote from our reservation, any dispute concerning or relating to the delimitation of maritime zones or arising out of, concerning or relating to the exploitation of disputed areas relating to maritime zones. And it's clear from parliamentary debate around the time and from answers in parliamentary committees that one of the situations that was intended to exclude was any claim by East Timor about the delimitation of maritime zones there. Another example of a reservation to the court's jurisdiction is that of the United Kingdom, which interestingly excludes from the court's jurisdiction any dispute it might have with any other member of the Commonwealth. But on the other hand, even though that might strike people as a very curious feature of international jurisdiction, the optional jurisdiction of the court also means that its judgments are more likely to have an impact. And of course, it reflects the fact that the language of state sovereignty remains very, very powerful in international institutions. So let me give you a sense of some of the cases that the court currently has before it. There are 8 pending cases in various stages of hearing and deliberation. Now, a number of these involve maritime and territorial boundary disputes. For example, there's an interesting dispute about maritime delimitation between Peru and Chile, and another one about Bolivia, a landlocked country seeking access to the sea. In another case, Ecuador has brought a case against Colombia about the effects of spraying herbicide on coca crops. So Colombia, as you'd be aware, is engaged in a program funded by the United States to destroy coca crops, and the Ecuadorian claim is that some of the herbicide, which is the basis of Roundup, which is probably a herbicide many of us use in our gardens, has gone into the territory of Ecuador and has ruined parts of the Ecuadorian forests there. In another very interesting case, Cambodia is seeking a ruling on an earlier decision of the court. Actually, the earlier decision of the court given in 1962 in the Temple of Preah Vihear case, Cambodia has come back to the court and asked the court to interpret its decision and to give a ruling on the presence of Thai troops and guards near the Temple of Preah Vihear. And of course, the case that's probably in many people's minds here, the whaling case. These are some pictures taken from the court website. The whaling case, which was heard just last month. This is a picture of members of the Japanese team about to argue. The agent for Japan on the left, Mr. Shiroka, and on the right, the leader of their legal team, the very well-known French jurist, Professor Alain Pellet, who stood out in the courtroom because of his glorious robes. This case, you'll be aware, brought by Australia against Japan, with New Zealand intervening. It's just concluded its oral phase, and the case, as you'll be aware, centres on whether Japanese whaling program, the Antarctic, JAPA 2, constitutes scientific whaling under the International Convention on the Regulation of Whaling. Here's a picture of some of Australia's legal team. James Crawford on the left, an Australian international lawyer who teaches international law at Cambridge. The Solicitor General of Australia in the middle, Justin Gleeson, and on the right, the agent for Australia, Bill Campbell, QC. Now, I'm currently serving as an ad hoc judge in the whaling case, and while I obviously can't speak about the case, a lot of people ask me what the role of an ad hoc judge is. And I must say, when my mother heard about the appointment, she rang me up straight away to express her alarm. She said, "That sounds so unfair that Australia has an ad hoc judge on the case. What sort of international justice is this?" So I had to go back, take her to the International Court Statute and explain that the role of ad hoc judges goes right back to the Permanent Court of International Justice. And the statute of the court provides that if there's not a member of one of the nationals of a party to a dispute as a permanent member of the court, that country can appoint a person as a member of the bench for that case only. And in the whaling case, there is a Japanese judge, Judge Hisashi Owada, and there is no Australian on the bench. Now, ad hoc judges are required to be independent of the country that appointed them, and they take exactly the same oath of impartiality as that of permanent judges. But the rationale for their position is that type of mediating function between the court and the party. Now, Judge ad hoc Hilary Charlesworth, who was a judge ad hoc in the case involving the application of the Convention on Genocide, a case between Bosnia and Serbia, to me offered very thoughtful reflection on the role of ad hoc judges when he made a separate opinion in the interim measures phase of that case. And he said, and this is a quote from Judge ad hoc Charlesworth's judgment, he said, "Ad hoc judges have an obligation to endeavour to ensure that, so far as is reasonable, every relevant argument in favour of the party that appointed him," and I should say there are no other women ad hoc judges, have been fully appreciated in the course of collegial consideration, and that those views are ultimately reflected, although not necessarily accepted, in any separate or dissenting opinion that he may write. I'd just like to finish with some thoughts about Australia and the ICJ. I think this is, I just want to show, this is to show that the proceedings before the ICJ are actually very collegial and friendly. Here is a picture of the two agents in the cases getting on well together. So let me think about Australia and the ICJ. For a small country in terms of population, we have been very active in the International Court of Justice. We've taken 2 cases to the court, and those are, of course, the nuclear test cases and the whaling case, and we've been the respondent in 2 others, the case taken against Australia by Nauru and the case brought against Australia by Portugal over East Timor. This is just my final image. I just want to show you, this is an image of the deliberation room in the court, where this is the judges sitting around discussing the drafting of a judgment after a case is heard. And this is taken some years ago, and perhaps you can see Judge Rosalind Higgins there, who was then president of the court from the United Kingdom, the only woman yet to be elected president of the court, sitting there. So this was, I think that photo was taken in 2005. But Australia and the ICJ, so far the only Australian elected to the ICJ was Sir Percy Spender, who was elected in 1958 after serving as Minister for External Affairs and then as Australian Ambassador to Washington. Sir Percy was indeed elected as President of the Court from 1964 to 1967. He's often remembered, I think he was achieved perhaps unwanted prominence in 1966 when, as President, and the President has a casting vote, he cast a deciding vote in a case brought by Ethiopia and Liberia against South Africa's refusal to report to the General Assembly on its mandate over South-West Africa, now Namibia. That his use of the casting vote was effectively a vote for South Africa by deciding that the court didn't have jurisdiction to hear the case. And the repercussions of that vote were quite extensive for Australia. Indeed, they were felt for a very long time. They're still remembered today, and they're said to have undermined the candidacy in the next round of elections of Sir Kenneth Bailey, the Australian Solicitor General, who was nominated by Australia in 1966 but failed to be elected. But the good news is that last year the Australian government announced that it would nominate Professor James Crawford, who you saw in an earlier picture, who's the Whewell Professor of International Law at Cambridge, for election to the ICJ. So this is the first attempt to have an Australian election since 1966. And he would effectively, if he were elected, he'd replace Sir Kenneth Keith from New Zealand, who has announced he isn't going to seek a further term. So if elected, Professor Crawford will begin his 9-year term in 2015. I think it's without too much national hubris, I could say that he's widely considered the leading international legal academic and leading advocate at the global level. And I think his election would be a wonderful boost to Australia's role in international law. So to conclude then, the possibility of a world court was first raised over 100 years ago in 1899 at the Hague Peace Conference. And today, I think, despite the limitations of its functions that I've referred to, and the fact that less than half the membership of the United Nations has accepted its jurisdiction, I think the International Court is an embodiment of the hope that adjudication can be an alternative to war. But of course, the effectiveness of the court can't be appreciated in isolation. It is part of the UN system as a whole. It's the premier judicial organ of the United Nations, and it certainly relies on the support and interest of other UN institutions. It also has to straddle the very delicate, the very fine line between the complexities of international politics and the great expectations of international justice.
Now we have a few minutes for questions from the floor. Does anyone have any questions? And we should have a roving mic somewhere, which is over there. And if you wouldn't mind coming forward, we have one question here. And when you ask a question, if you wouldn't mind just saying who you are, introducing yourself first. So we have one question here. Were there any other questions? So then there and then there. So.
Thank you. Thank you for your very interesting talk. I'm Ruth Russell from Women's International League for Peace and Freedom. You mentioned one case that had an outcome, which was the legality of the separation wall that was being built in Israel and Palestine. Now, I'm just wondering, what is the actual outcome of that? Because is it just a moral victory that they declared it illegal, or how can it be implemented when a decision's made that was clearly made that has huge significance for the peace, I suppose, between those two countries?
Yes, thank you for that question. It was, as I mentioned, an advisory opinion, and you raised the important issue of what's the status of advisory opinions. By their very nature, they don't bind. That's absolutely clear. And some might say, well, and of course there was an opinion of the court, and there are a number of separate and dissenting opinions. So it's quite, if you look at the judgment, it goes for hundreds of pages. And there has been a lot of debate in the literature. What was the purpose of this? Was it worth the opportunity? I think one of the things that said, what's the value of this advisory opinion, which did say that the barrier wall was a violation of international human rights law and also international humanitarian law. So there are some very strong statements in the court's opinion to that effect. One important thing I think it did was, at the symbolic level, was to allow the arguments to be put in this very formal setting. Israel boycotted the proceedings. So unfortunately there was no opportunity to actually hear the Israeli response. And of course, because it concerned that country directly, that was a pity that there wasn't the opportunity to hear a considered sort of legal argument. But I think the strength of the court's judgment, its unequivocal statements on these points, I've seen those used in, first of all, they've been referred to in subsequent judgments of the court, admittedly on different issues, but the principles that the court set out have been reinforced. And I've also, it's been used extensively by civil society, the judgment of the court. So I think we have to look at more subtle enforcement mechanisms than the idea that one could go in and simply tear down the wall and say we've got a judgment here. One's just looking, and of course at the international level, that type of immediate response that we imagine is possible to court decisions simply isn't possible. But I think in time, and it's interesting how often one sees references to to the court's decision in that case, and I think it's becoming sort of, it's strengthening, I think, the understandings of both humanitarian law and human rights law.
Next question, gentleman over there.
Dirk van Berens, Canberra Friends of Dili, one of the friendships groups with East Timor, Dili being the capital of East Timor, of course. What I'd like to ask is, would it strengthen Australia's case and standing internationally if we remove the reservation about that we have lodged in 2002 about the jurisdiction of the International Court in the case of the boundary dispute with East Timor?
I don't want to speak about that directly, because I don't know if you're aware that reservation has been invoked by Japan in the whaling case. So it's not possible for me really to speak about that directly. I would just simply say, I suppose, at a general level, and international lawyers would always argue, this is our role, I think, for acceptance of treaties without reservation. But reservations, of course, often are a very important way for particular countries to, as it were, customise their acceptance of particular treaties. I think that is the political reality. And so one has to always consider when, and I must say I've certainly been very, very critical over the years of the, say, extensive reservations to human rights treaties that we see by many countries, including Australia. I think we also have to recognise that they are sometimes the precise condition on which a country will accept jurisdiction, and so you'd be left with, well, is it better to have a country not accepting jurisdiction at all, or accepting it with reservations? And I think that's an intensely political decision that probably lawyers don't have a lot to add to. So I'm sorry to really duck your question, but I need to in this case.
It's Clem Campbell from the United Nations Association, Queensland. My question is about jurisdiction for what is known as super international companies. In other words, 44 of the largest economies in the world are now actual corporations. Who has jurisdiction over those, especially when they often act as an agent for a government or for a state?
Well, again, it's a very good question. I mean, the court, it's clear, only has jurisdiction over states. There have certainly been cases that have come before the court that have involved corporate activities where a country has been effectively, as it were, identified with the company. So it's possible for corporate activities in some contexts to come before the International Court of Justice. But who has jurisdiction over them? Well, that's they have to be, every company has to be incorporated in one place. And it's usually the law of the place where they're incorporated that governs their activities. There have been various attempts at the international level to try to allow more general international jurisdiction over companies, to treat them differently to individuals, for example, who carry a passport and have a nationality. And these have been sometimes a little successful and sometimes not successful at all. But this is a major issue. And how far one can, as I say, the system I've been talking about, a very, very old structure, certainly was devised at a time when the critical players in the global community were nation states. That has changed profoundly, but at least the ICJ hasn't yet caught up with that. And there have been various initiatives, of course, to try to get international standards, and I think at the conference we're going to hear about these through, for example, the Global Compact. But this system of adjudication is something that certainly doesn't cover them squarely, and one has to look right back to national jurisdictions to cover them.